afternoon. We're going to take up the case of people of the state of Michigan versus Roberto Ronaldo Alvarez II. This is file number 26-14222-FH. Appearances, please.
Please it all for the people.
Robert Hartzell, Mr. Ambrose, who joins me to my left here.
All right, thank you very much. And I think I said a probation violation, but it's actually a bond violation.
That's correct.
Yeah, thank you. All right, so this court issued a bench warrant. Let me first go over. Go back. Court ordered the defendant to appear for an alleged bond violation. That initial hearing was scheduled for March. It was issued by me. I remember having this difficulty last week. 1 second. There we go. This court issued a show cause as to why bond should not be revoked. That order was issued on March 10th of this year. The hearing was scheduled for March 23rd of this year. The allegation at the time was that the defendant allegedly violated the terms or conditions of his bond. I keep saying probation. I don't know why I keep doing that. That he allegedly violated the terms and conditions of his bond by committing a new offense, specifically a trespassing. The court then set the matter, as I mentioned, for March 23rd. Then, because the defendant failed to appear on or about that or on that date, the court then issued an arrest warrant. The defendant failed to appear also on March 27th. The court added that to the bench warrant, which was signed on March 30th. And we were here on April 3rd for an arraignment, and the defendant elected to have a contested hearing, and that's for what we're here today. What are we doing, Ms. Dahl, now that I got us up to where we're at?
My understanding is that he would be pleading or taking responsibility for his failures to appear, and we would have a contested hearings on the other two violations, one being that offense trespassing, and one that he was in possession of a weapon in violation of his bond condition.
All right. Hold on. Okay, and are we going to do that hearing today then?
I'm ready to proceed.
All right, Mr. Hartel, is that correct?
It is correct, Your Honor.
Let's go ahead and begin with the contested hearing portion of it first. Thank you. Ms. Dahl?
Your Honor, may I approach?
You may. Thank you. Thank you. All right, Ms. Dahl has handed to me a couple of documents that have exhibit stickers on them. The first one is People's Proposed Exhibit number 1, which is a incident report from the Cadillac Police Department for an alleged date of March 8th of 2026. Incident number is 26-592. And the second is People's Exhibit number 2, which is the proposed Exhibit 2, a complaint of a violation of the conditional release, which apparently has been presented or was prepared by one of the police officers for the city of Cadillac. Looks like that was Officer Ryan Brust, B-R-U-S-T. All right, Ms. Dahl, are you asking the court to take these into consideration to support the allegation for the original trespass?
Yes, Your Honor, and I'm asking the court to take judicial notice of the pretrial release order signed by Judge Wiggins.
I've got it.
Thank you, Your Honor.
Yep, no problem. Thank you. It was initially signed probably by his magistrate on or about February 18th of this year. And specifically, the term or condition would be paragraph 5D, not to commit any crime while released. All right, and
Also, Subsection E, 5E would be do not possess or purchase a firearm or other dangerous weapon.
Thank you very much. All right, Mr. Hartel, as to the judicial notice of the pretrial release conditions and as to the admissibility of People's Exhibits 1 and 2.
Yeah, as for the exhibits, Your Honor, we do, of course, realize and respect that it is a lower standard, these type of hearings. The defense doesn't feel comfortable stipulating to such. We prefer the opportunity to voir dire the officers, but we realize the court has discretion in this matter. Thank you.
Thank you. The court takes again judicial notice pursuant to the court rules. That's specifically, I think it's 201. And then as to the admissibility of these exhibits 1 and 2 pursuant to Michigan rule of, it's not court rules, rules of evidence. And now this one would be rule of evidence 1011, I think. Anyways, the court knows that for today's pretrial release conditions, the rules of evidence are relaxed. Therefore, the court commits People's Exhibits number 1 and number 2. And I will now take a moment to read through them. Oh, I should have said even more thoroughly that People's Exhibit number 2, which again had the complaint of a conditional release violation from an officer, that attached, I'm sure that included an attachment. That attachment was his mother's City of Cadillac Police Department report for a date of an offense on March 3rd, April 3rd of this year. And that incident number is 26-836. And again, that is from the same officer as the first. No, the other one was Nick Dahl. But anyways, all right, I'll take a look at that one. All right. Ms. Dahl, any other evidence to present us to those issues?
No, Your Honor, my understanding is the other count of failure to appear is going to be.
Mr. Hartel, any other evidence on your, is there any evidence on behalf of the defendant to submit?
No evidence, but I would like the opportunity to make a few statements about what's.
Oh, of course, we'll do arguments here in just a second.
Thank you.
All right, Mr. Ambrose, if you would please raise your right hand. I'm only going to ask you a couple limited questions. You swear or affirm the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth? Yeah. You may, Lord. Mr. Ambrose, did you know you had to appear in a couple dates? Like I told you to come here for a show cause?
I did after the fact.
All right. Well, I'm not going to make a ruling yet on that. I'll turn to Ms. Dahl. Ms. Dahl, any argument to talk about the facts, and then you can suggest what the court should do. So in other words, address both arguments. Thank you.
Your Honor, in this case, he was out on bond and was informed by his conditions and by the court that he is to obey all laws on the court when he is supposed to and not possess any weapons, because the underlying charge here is carrying a weapon. After he was released, he violated those 3 conditions. I believe that he should remain remanded until he is sentenced in this case. We do have sentencing coming up. I believe if he is to be released, he poses a risk danger to the community and also a flight risk. So I believe at this point he should was originally scheduled for April 20th.
Thank you.
Okay.
Mr. Hartel, you may present both arguments.
Yes, Your Honor. I suppose I'll compartmentalize it a bit. I believe my client would like to make a statement if there is a finding of bond violation, but we'll wait on that.
Okay.
When it comes to the accusation of new criminal activity, just so the court is aware, my client's been very clear he plans to fight that charge. We do expect that to go all the way to trial. The report that ended up being admitted, if I recall correctly, he did state to the police officers in that report that he believed he lived there. Now, whether or not that ends up becoming the finding down districts, we'll find out when we find out. But even in that report, he told the officers that he believed he lived there. So I would ask the court to factor in that I don't believe that rises to the level of a trespass. As far as the weapons provisions, with that particular item, I know the court made a finding that the instructions for him being on bond included no weapons, but with something, I can see a lot of people, I know he's electing his Fifth Amendment rights on this portion, but I can see a lot of people thinking the smaller little pocket knives don't fall under that. I know colloquially, when people hear weapon, they think of the more extremes we see, the folding out switchblades, the serrated, the two-sided, the daggers. I remember a gentleman, without saying his name, who had a homemade spear a few towns over. The court may or may not remember that case.
I remember that one. We don't see the word spear mentioned too often.
Correct. And that's definitely not something we're dealing with here. I know it doesn't have to be that standard, but I'd ask the court to factor in the reasonableness of that as well. But especially, again, on the new criminal activity element, as far as the failure to appear, I know that's a bit more wonky. I believe the court can take judicial notice without my client's statements that he wasn't here before, Your Honor. I know that sounds like perhaps I'm arguing against myself a bit, but I know we came in here with that goal, and so I do believe I'm articulating my client's goals when I say that. If there is a finding of guilt, I would ask the court to still release him. He would like to make a statement about where he would go and what he would do. He does have a mother who's ill. That is still in the state of Michigan. He'd like to visit with her, but stay mostly in the local area. We're not contesting the portion, we're not saying no contest, but we're not contesting the portion of him failing to appear. He did let me know that he had some issues with rides and communications. He's resolved those issues, and he does believe they would remain resolved if released. And again, he's willing to make limited statements in that when the court's ready for that. Thank you.
All right, so the first thing the court's going to do is make a ruling on the evidence, and then I'll turn to Mr. Ambrose at the end. Well, in the first exhibit, this talks about an incident that occurs regarding the trespass over on 934 Sunberg Street on March 8th. And reports here in this exhibit that a young woman named Cassandra had called. The law enforcement officers came. She informed that she had directed and wanted the defendant, Mr. Ambrose, to leave her property, and that he had failed to do so. And then when the defendant stated that he believed he lived there, the officer reported that he knew that Mr. Ambrose lives at an address on Farrar Street because that officer had just dealt with the defendant the night before someplace, and that he informed that officer that he lived on Farrar Street. So there is an issue there with credibility, and the court finds the defendant, at least for today's purposes, recognizing that today's burden of proof is a reasonable cause. Therefore, the court finds the defendant committed a trespass. And I'll also note it sounds like he was providing false information to an officer, but it doesn't reach the level of a crime because it doesn't appear to have been regarding a felony. And taking a look here at People's Exhibit number 2. So this one here includes facts that not everybody met, that no one else mentioned, at least I didn't hear it. This here occurred just about a month later. I issued my warrant back on March 10th. The defendant failed to show up a couple times. I'm not going to find the defendant his failure to show is my reason for a bond violation, but I will use this part. Well, the defendant again violated the law, at least according to this, based upon the lower level of or burden of proof that the defendant, quote, a male subject wearing a full face mask ran off into the residence. The officer called for assistance. So the officers tried to stop the masked man, and the masked man took off. That masked man later was asked, who is he, when he was caught inside the residence. And he said his name was Alan, and he kept wearing the mask to hide his face. That's interesting. Makes me wonder why he was hiding his face. Maybe he did know that there was a warrant. Regardless, I've already said that I'm not going to find him guilty of violating the warrant because I don't have anything, I don't have a lot further, but I'm also going to eliminate any argument issue there. And this gentleman, when he was apprehended, because they knew who he was, even though he tried to lie about who he was, placed him under arrest. And when they did, the defendant, a gentleman at 2:30 in the morning, wearing a face mask and carrying a curved fixed blade knife, definitely suggests that he's carrying a weapon for weapon purposes. Therefore, the court finds the defendant in violation of his bond based upon those facts contained in People's Exhibits 1 and 2, and I will negate the other original allegation. I'm sorry, the intermediate allegations of failure to appear. Now, I've already heard from Ms. Dahl and Mr. Hartel. Mr. Ambrose, Mr. Hartel told me you wish to be heard before I make a decision about what to do with bond. Is there anything you wish to say?
I apologize for not showing up first off. This is the second. So I would, the bond was posted by the woman Cassandra.
Mhm.
We got that address. And then when we left this courtroom, we left the courtroom, we made my address the address, which is her address.
Is that right, Madam Clerk?
934
Hold on,
suburb.
hold on.
Okay.
You show an address on far.
Right here, it says 934 Sunbury.
Hold on. Take a look. Now, on the first document, which was the one from the event of April 3rd of this year, which was the second, and that was listed in People's Exhibit number 2. Your address there is listed as 802 Farrar Street.
I recently changed that because of the trespassing.
Well, you may have, but that's what it said.
Okay.
And then on the report for People's Exhibit number 1, it lists the same address of 802 Farrar Street.
Okay.
And there's a statement inside one of the exhibits that says you had told the officer the day before, which must have been on or about April 2nd, that you lived at Farrar Street. And the court notes that, the court clerk tells me that your record there is 802 Farrar Street. Now, you can change it to something else, but that doesn't mean anything unless I have Cassandra come in here to say, yeah, he was living. I could change my address I'm sorry?
There's video evidence and.
I don't have that.
Photos,
I don't have that.
you know,
So it's not presented to me. I don't go get evidence.
but-
I just sit here and I wait for people to throw pitches. So I could also change my address to that one big white house on Pennsylvania Avenue, Washington DC.
I understand.
Doesn't mean I live there.
Right, right.
Heck, I wouldn't ever want to live there. But anyways, all right, well, so here's what the court's going to do. The court's going to deny bond, revoke bond, remand the defendant into custody pending our sentencing, which sounds like it's just going to be in a couple, not even a couple weeks, yeah, about 11 days, I think is what I just heard, maybe it's 12 days. All right,
Judge,
yeah,
that date was removed, but due to the warrant.
okay, well,
Don't
I'll.
know if it can still be scheduled. that
Yeah,
day.
I'll see if I can have it sentence. I'm gonna say, bond revoked and set for sentence. Can we still do it? Was that the 20th? Is that what he said, man? I heard. Thank you.
Yes.
All right, we'll see if we can get that set back on the 20th, which it don't bother me any, so I'll be here. So, and if we had time a week or two ago, I'm sure we still have time. So I'll make sure that that gets done. All right, folks.